affidavit wherein you specifically addressed what was said in paragraph E of that affidavit. Do you recall?
Yes, I do.
Thank you. Furthermore, you said you then made the following remark, and please correct me if I don't quote you accordingly or correctly. You stated that the applicant does not say that she went to the flat alone to refresh. She left that part of that information out of her affidavit. Am I capturing you correctly?
That is correct.
Okay, and then the court asked you if that act was recorded in the occurrence book of the security guards, and you confirmed as such.
Yes, I did.
Okay, that's fine. In respect of that, yeah. With regards to that paragraph and in respect of that information that you related yesterday, is there anything else that you want to add in respect of paragraph E? Page 6 now of the affidavit.
Yes, like I said, I felt having had this affidavit being read before this court last week Friday, and understanding that the facts of this affidavit are in sequence. When I was looking at the following paragraph, which is paragraph E on page 6, I felt like something was being left out. That was my concern, because if the facts of this affidavit are in sequence, I felt that should have been included before we go to paragraph E. However, it's not my affidavit.
Very well. Let me just take you a step back a bit to paragraph D of the very same, on the very same page, and it reads as follows. After Jayden was pronounced dead at the Discoveries Hospital, we waited until the forensics and pathologists arrived, and we went back to Swazi Place. Do you know anything about that? This is what the accused is saying, or rather the applicant.
With that one, if we are to go a little bit back, let me look for the paragraph where I feel that is in contrary with what has been said before. I will look for the Please bear with me. I'm looking for the paragraph that we touched before this one.
Okay. They're causing us to fidget now, you know, just to while away time. Are you finding it, Mr. T?
No, I'm not finding it, but there's somewhere where the applicant mentioned that police officers came. I suppose she was at the crime scene, but I know the pathologist arrived at the crime scene later that day. So this is in contrary to something that I read. I'll find it out at a later stage.
Are you searching in her affidavit or?
Yes, in her affidavit.
Or in pages after this one?
I think this page was before this one. The problem is I read over to this over and over again.
Okay.
Okay. Yeah, it's after it's paragraph H on page 6.
Okay. Oh.
The photographer arrived at 1300 hours and took photographs inside my flat. Now, you say after Jayden was pronounced dead at the Discovery Hospital, we waited until the forensics arrived. I assume here on H, she was at the scene when she says the photograph came at this time. However, when the child was pronounced dead earlier, it was in the morning, but for pathologists, they came later, and I believe she waited until the body was removed.
Okay, well, that's
so
fine then.
the times
Just a
are...
moment. Just a moment. Yes, continue, you see?
Okay, having facts of these, all these paragraphs as they follow each other, how they are written, it suggests that she could have been in two places at the same time. That is my point.
Apologies, to object to that last. I'm not sure how the witness is drawing that inference. At no stage in paragraph H does the applicant state, I was present when the photographer arrived at 1 p.m. That was not...
Noted.
Thank you, Ashik.
Let's go. Yes, I wanted to ask you, all right, when you say the pathologist arrived late, what would you mean? What?
It was in the afternoon,
It's around what time?
around 2,
Around 2.
1400 hours.
So according to you, now that she asserts in her affidavit that the photographer arrived around 1300 hours, and yet in paragraph H, as you highlighted, and yet in paragraph D, she says, after Jayden was pronounced dead at the Discovery Hospital, we waited until the forensic and pathologist arrived. So which means she would have still at around 1400 hours should still have been at the hospital.
That's my understanding.
Yes. Very well. Okay. Paragraph F. Yeah. At approximately 10 a.m. on the same day, my sister Simone opened my flat and allowed the police in. They searched my flat, and a member of the Hawks division was also present with members from Florida SAPS. Do you have a comment or do you have knowledge of that?
No, I don't.
Okay. Paragraph G. It should be noted that Jayden's school bag and school uniform was not found inside my flat on the 14th of May 2025. That's paragraph G. Oh, I use woman. Miss Park. Oh, thank you. Yes?
That is not true.
Yes. What, according to you, what is true?
The photos taken on that day depicts the photos of the school bag of the child as the books were checked inside.
Just a moment. Yes.
The book that was taken from the school bag before the photos were taken shows the report of the child that was taken from the school bag, and the picture or the photo of the school bag was taken on that very same day. Therefore, I dispute this statement.
Okay. You know, we want certainties. When we say taken on that day, let's confirm.
On the 14th of May 2025.
Let's go to the school report. Where's the photo? I believe there's a picture taken. Does that report, you said, depicts the name, depicts the school?
Yes, Your Worship.
Does it depict a date?
No, it's the books inside that depicts the day, but the report only reflects the name of the child.
How does the book reflect the date?
There's work dated.
Exactly. So do you have photos of that?
No, the school bag is sealed in a forensic bag. It was checked before the bag was sealed.
Where's that book?
It's in Florida SAP 13, Your Worship.
I want the book.
I can ask one of my colleagues to go and book out the
Do you
bag.
understand the relevance?
Yes, I do, Your
Take a
Worship.
photo of a school report. Yes, I understand. It gives clarity as to who the bag belonged to. It speaks to that. But if the argument here is about the day when it was discovered, and the time, for example, because the photographer was there, then obviously that school book bearing the homework of that day speaks to the timeline.
I understand, Your Worship.
Okay, continue. Let's have a look at that report quickly. I've asked for a file review compiled. Has anyone done that?
Not yet, Your Worship. Should
Yesterday. Can someone start doing that?
I will, Your Worship. No, I will. The photo of the school report. Oh,
Thank you.
You may have leave to approach the accused.
Yes.
Thank you, Your Worship. Your Worship, the accused has no knowledge of the report.
Thank you.
Thank you, Your Worship.
And he said,
Worship, may I just also add, the accused stated that the date of death of the child was the 14th of May and term 2 only ended in June, according to her knowledge.
well, it more speaks to the bag belonged to.
Yes, Your Worship. That's what she's saying. She's never had sight of the document until today. So she has no knowledge how that report is part of the exhibits. If term 2 would have only ended around the end of June.
Unless the report was forgotten in the school bag. Just a possibility.
Possibility, Your Worship, but the accused has no knowledge of it.
Absolutely. the school report, it states that it is term 2, 2025, and this holiday work for grade 6, English home language.
As correct, Your
So
Worship.
it's holiday work. Be that as it may, your client maintains she has never seen this.
This is the first time she's seen that document, Your Worship.
But she confirms that the name of the learner here is Jayden-Lee Meek.
Correct, Your Worship.
Okay. This will form part of the exhibit bundle state.
Yes, go, please.
Thank you, Stuart.
Let's go, please. We have dealt with paragraph H. Let's then continue to paragraph I. The dog unit and detectives arrived at approximately 1400 hours, and the forensics team arrived around 1500 hours on the 14th of May 2025.
That is my understanding.
Okay. Paragraph J. The sniffer dogs followed Jayden sent to the flat where the security guard was living, but the police refused to enter his flat, and we were once again informed that the police had no search warrant and could not enter the guard's flat. Let me repeat that. The sniffer dogs followed Jayden sent to the flat where the security guard was living, but the police refused to enter his flat, and we were once again informed that the police had no search warrant and could not enter the guard's flat.
With regards to search warrant, having explained to whoever, I cannot say anything to that, but with the scent being followed by the dog to the security flat, my knowledge and my understanding, securities have never occupied any flat to Swazi's place.
Just a moment. Yes.
Therefore, if it said the dog followed the scent to the flat of the security, I'm not sure which flat will someone be referring to.
Just a moment. Yes, continue.
No, that's it.
Okay. Remember earlier when we... No, besides. Okay. So what you're saying is the security guards don't have any form of occupation. Let me eschew using that word. So they don't have any form of residence in the complex at Swazi Place.
Yes, they only occupy the guard room. They end at the guard room, then they do their duties.
So let's use the guard room as the narrative here.
So when you say flat, I assume is referring
No,
to...
I hear what you are saying. Let's take that out of the equation. If the meaning was that it was the guard room or the guard house, do you have any knowledge of the sniffer dogs going to the guard house?
No, I don't.
Yes, and then earlier you had indicated, just want to confirm, earlier you had indicated that when the police, on the 13th of May, when the police went about now questioning the security guards, they started with the one who was on duty, isn't it?
Yes, the night shift guard.
And then with further questioning, then he revealed that no, someone else was on duty at the time that the child would have returned from school.
That's correct.
Yes, and then you further indicated that then this security guard who was now on duty took them to where the day shift duty security guard resided.
That's true.
Yes. And you indicated, okay, how far did you say that would be from the complex at Swazi Place?
I said it could be plus minus a kilometer. It's not that far.
Okay. Now, then further, paragraph K. They are members of our family, community activists, friends, and members of the community were in and out of my flat on the 14th and 15th May 2025.
No, I don't know nothing about it.
You said, in that regard, you said that Captain Hoffman was the person who has taken charge of the scene.
Yes, Your Worship.
And she has done that since what day?
On the 14th, Your Worship.
Do you know what time she arrived?
No, I'm not sure. I'm not sure, Your Worship.
But she made a statement, according to you.
I'm still waiting for a statement, Your Worship.
Proceed.
Yes, God, please. Where is Captain Hoffman stationed?
At Florida.
Okay. And then paragraph L. On the 16th of May 2025, we were contacted by the police and informed that they were unable to gather forensics and evidence on 14 May 2025, and they wanted access to the flat.
With this one, I'm not sure who called. However, I was at the crime scene on the 16th of May.
Just a moment. At what time?
It could have been around 1600 hours to 5 in the afternoon.
Yes. Continue.
We were with the member of the family of the applicant.
Mm-hmm.
He opened for us.
Yes.
And we did the work we were there for.
Let's specify. What is the work that you did?
I collected the school bag.
Okay. Mm-hmm.
And called the photographer again.
And when you collected the school bag, what was anything in it?
Yes.
Okay. What was in the school bag when you collected?
It was a lunchbox, a pink lunchbox,
Lunchbox. Mm-hmm.
books.
Mm-hmm.
I took out one book. In that book, that is where I saw the work of the day the child reported missing.
Okay, just a moment. Mm-hmm.
The reason I went there on that day, one of the reasons is that I took an initiative as the investigating officer, seeing that
Just a moment. Mm-hmm.
seeing that the photographer took the photo and the book, the school bag was not taken. It was left there.
Okay. Okay, just with you. Okay. You remember yesterday you showed the court the photographs where the books were found on the, were photographs on the 14th of May. Yeah?
Yes.
So are you saying when you went there now to collect these exhibits, the photographs were taken again?
Yes.
All right, fine. Then will you then please show us the photographs?
Of the day.
Yes, sir.
The photographer said he used the recording. He has the recordings with him.
Recording.
Yes.
Okay.
What does that mean?
Yes.
He said he videoed the occurrence of us taking those
On the 15th.
on the 16th Yoshi.
Is that going to be translated to still photos?
I don't
It's a
understand.
recording.
Yeah.
It's been made a recording. So the question was, what is there any photographs?
No, he said he did the recording. He recorded. He didn't
Yes,
take
we
the
understand what you are saying.
photo.
Yeah. If I may, Bishop,
Yes.
what the court is asking is, can you not,
Produce still photos.
yes, like freeze an image, take a photograph, freeze a moment, freeze a moment, and then take a still photo.
No, I can ask him to do that.
Please,
I can ask him to do that.
it's important.
Uh,
Now, what I want to know is it the same photographer who took photographs on the 14th of May?
That's correct.
Okay. The following comment is going to be based on the assumption, and really it's an assumption that we will take lunch. Look, during lunchtime, please, if you can contact the photographer and then ask or inquire perhaps as to when can he have those exhibits available for the proceedings. And please emphasize that it's urgent. Yeah? Thank you. All right.
They're saying that maybe also ask that the recording be made available to the defense.
Compare.
To compare, because we don't know if
Makes
it's one in the same photographs as to compare to the recording.
It makes sense. Let's proceed.
Thought we'd have everything. It's fine. Oh yeah, let's go back to your activities now at the scene. Yes. All right. You said you took the initiative and you took the initiative as the IO, seeing that the items were not taken. You may proceed from that point.
Oh, that's all.
Oh, okay.
I seized them and booked them in the SCP-13.
What is the register number? SCP-13?
The Florida SCP-13 number reads as 667/2025.
667.
Yes, /2025.
Oh, okay.
Read the items that's so booked. Read your items that's so booked.
1 black school bag containing school
Just a moment,
books.
Go
just a
slower,
moment.
please.
1.
Black school bag
Okay.
containing school books sealed in forensic bag number.
Just a moment. Sealed in forensic bag number.
P4B 000.
Okay. Wow. P4B.
Yes.
000.
000 36.
These are 3 zeros.
Yes.
Thanks. No, it's fine. Yes. 3.
36.
Yes.
36 again.
Yes.
54.
So what we take here from is that that is the only item you moved on that day.
Yes, Your Worship.
Okay. Proceed.
That's called business. Oh yeah, all right. The next page, page 7, paragraph M.
Can you just stand? Let's pause a bit. There's quite a lot of emphasis placed on the school bag if you go to paragraph G. But the applicant, in non-certain terms, also state that a school uniform was not found inside her flat. Do I therefore take it, because you don't address that issue, that you also have not found a school uniform?
We did found the uniform, Your Worship.
Yes. On what day?
It's only pictures that were taken for uniform. I never collected it to the 13th.
So that picture was taken the Thursday, the
Yes,
deposit week.
yes, Your Worship, on the 14th.
Do you have a picture with you?
Yes, Your Worship.
Can I view it, please? What day will that be? 14th?
Yes, Your Worship. These pictures were taken on the 14th.
Yes.
Your Worship, it's the same photograph as yesterday. It does not show a school uniform. It shows a hung up red jacket and a few pairs of shoes. If the witness can point out where exactly the uniform is. Thank you, Your Worship.
Explain that photo for the record.
The jacket hung up on the rack of the wardrobe. It had that logo, Royal College. And the school shoes, to me, the taffies are known to be school shoes, not shoes to wear someone else. So, hence I'm saying we saw the uniform on
So it
the...
had the school logo, and you assume the stuff is purports to be the school shoes.
Yes, Your Worship.
Let's have a look.
We also see clarity with the court's question from the witness in respect of, when we talk about uniform, if he's referring to the pants and the shirt that the child wore on the day in question, if we can get clarity on that part of the uniform.
But your client concedes that that is a school jacket worn by learners at the school where their child attended.
That is correct, Your Worship, but on that particular day, the child did not wear a jacket to school. But that will come on cross-examination.
Thank you. Also to be marked part of the exhibit album.
As copies.
Photo number.
That's 31, 32. Let's proceed.
As copies. Page 7, yeah, paragraph M. Okay. The photographer was also present for the second time, and this is when the entire case took a turn and I started to get framed for Jayden's murder. It's a bit vague, but would you have a response?
Only on the term of framing, the investigation has since, from the onset, been done the way it's supposed to be done. However, I see no reasons why should we frame someone. So the framing part, it's something that I am not agreeing with.
Mm. But just out of curiosity and perhaps, just for completeness, if I may put it that way, prior to you investigating now this case and and knowing about the applicant and knowing the applicant, is she someone you've known before and had any issues with before?
No, I don't have issues with her. It was my first time to see her the morning of the incident, which was the 13th. Got no personal issues with her since I knew her. I was just doing my work, so I've got no issues with her. I've never seen her before the incident.
Okay, paragraph N. I was informed that his school bag, uniform, blood-stained underwear, and bed sheets with his blood were found on 16th May 2025.
Her informer could have partially given information, not as things unfolded.
What do you mean?
When blood stains, these things, they were there before, like the school bag was seen on the day of the incident, not only on the 16th. It's not like on this day it was for the first time these things are seen. The uniform was seen on the first day, the school bag was seen on the 14th, the blood stains was seen on the 14th. Underwear and bed sheet, these ones, on this 16th there was this underwear in the bathtub, but I cannot tell if it was there then on the day I'm mentioning the others. Yes, these things were seen, but it was not for the first time they were seen on that day. The ones that I've mentioned before, the school bag, uniform, blood stains on pillow, not on the underwear. I didn't see blood on the underwear. Bed sheet, I didn't see. So those, the school bag, uniform, blood stains, these things, it was not for the first time they were seen on this 16th. They were seen before, and they were captured as they were seen.
So repeat for the record, the very important part. You did not see bloodstains on underwear?
Yes.
And?
On the bed sheet.
And bed sheets. No bloodstains.
On the 16th. The things that are written on the first sentence, first line of paragraph F, those are the things that were seen on. It was not for the first time they are seen that day.
But the latter part you bear no knowledge of. There have been bloodstains.
Blood stains.
On the underwear and the bed sheets.
Not on those.
In fact, the wording is clear. I think it's referring to blood-soaked. That's a very poignant word to use.
On the underwear, I didn't see blood. There was a towel. The towel had traces of blood that leads to the drain of the bathtub. That is not mentioned here. Now I'm mentioning something. I was trying to stick on what is written here.
So the towel purported to have blood stains on it. But that's separate investigation. It's not mentioned
No, it's on.
initially by you. You think?
I don't understand you.
Okay. So you said there was a towel that was covering the underwear.
No, it was not covering.
But it was-
It was placed next to,
Okay.
inside the bathtub.
But you saw that there was what on the towel?
Something like traces of blood.
Is that still with forensics?
No, we never took it, Your Worship.
Why? Why?
Your Worship, that never crossed my mind. Since a number of things were already sent, that never crossed my mind.
Well, you're not barred from doing it. You still can.
Yes, if it's still there, I can, Your Worship.
Let's proceed.
Let's go business. Okay. Paragraph O. Okay. It is highly improbable and impossible for the police to have not seen or found all these items as alleged on the 14th of May 2025. Suppose we've dealt with it. Do you want to comment on that?
No, the only thing I can add is that with the explanation I have given, this is a true statement.
Which one?
The one that you've just read. It is highly improbable that police officer could have missed these. As I said, police officers never miss these things, so this statement is true.
No.
Because you have to read the converse into it. That in fact they did on 14.
Yes, Your
That's
Worship.
the argument.
Yes.
That's the argument.
Yes. I was still.
Read the converse into it.
I was doing that, Your Worship.
Thank you so
Yes.
much.
I was reaching into the depth of my English
I understand.
as the court pleases. Now, paragraph P. Further, I am confident that the moment that Jayden's blood-soaked clothes and school bag was found, I would have been arrested immediately and not almost 2 months later by the police. What is your comment?
This is not correct when you understand the standards of investigation.
Just a moment. Yes.
As standard of investigations, we don't arrest to investigate. We had to gather a lot of things before we could say now we're having a case against the applicant.
Just a moment. Yes.
As I have mentioned yesterday, the blood that was taken from the pillow had to be taken to biology to be analyzed. That is not something that is done over a night.
Okay.
The post-mortem report, as I said, the doctor couldn't give a final report immediately. The post-mortem report is what points to what caused the death. Therefore, we couldn't just arrest the suspect because we're having a school bag and something without knowing the cause of death to the child.
Let's pause here. What's the injury sustained according to the post-mortem? You understand what's the cause of death? What is the injury sustained according to the post-mortem?
Let me read it to you. It's blunt.
Not the cause, the injuries. Just go to paragraph 4 and 5 of the postmortem report. In Roman numerals, it will be what? IV and V.
Okay. Okay, that the chief postmortem findings in this case were colored male child in a state of undress with minor external injuries, no visible defensive injuries. There are no visible. Okay, deep scalp hemorrhage with underlying cerebral swelling. Just a moment.
Deep skull hemorrhaging with underlying.
Cerebral swelling. Cerebral swelling.
Yes.
There are no significant finding on bloodless neck dissection.
The witness just repeat that, the last part, Your Worship.
Repeat the last sentence.
The
No.
second one. There are no significant findings on bloodless neck dissection.
So no significant finding of the neck dissection. I
They
want
did-
to link the post-mortem to what was noticed when the child was found or observed. It is said that there was a small cut noticed to the forehead. There was noticed bruises to the neck and the arms. There were specifics given also to a right leg. And there was blood on the lips of the child. I want to marry this with the post-mortem. Please link it,
Okay,
if possible.
okay, Worship. I'll go to page 4 of the postmortem report. Injuries. 1 centimeter by 0.3 centimeter. That is point number 1.
1 by 0.3.
0.3 centimeter
Yes.
linear reddish abrasion above the lateral right eyebrow. Second point, 1 centimeter by 0.3 centimeter linear reddish abrasion lateral to right lower lip. There is that is point number 3, 5 centimeter by 3 centimeter green blue bruise just above the posterior right elbow. The bruise is in the shape of incomplete dental acres. There are no visible defensive injuries. those are the things noted under
But
injury.
repeat the last part. There's no visible defensive injuries.
Yes, Your Worship.
Sometimes the post-mortem speaks a timeline. What I mean by that is post-mortems normally give you indication as to the time period as to when the injuries were sustained. Does the post-mortem give you indication whether it's healed, whether it's fresh, whether it is in the process still of healing?
Let me check, Your Worship, if is there anywhere where it's...
If those words are appearing anyway.
Your Worship, I see nowhere where that is stated, but I can find out from the doctor if she can make such if requested.
Because that's important to understand when the death occurred. It paints a picture to the court as to a window period. Do you
The
understand?
freshness of
Yes.
injuries, I do understand. Your Worship.
Because every wound has a time frame attached to it.
No, I can find out from the doctor, Your Worship.
Let's proceed.
Worship, I'm not sure if the court's permission, if I may go inside into the postmortem.
Yes, I also want to part of my bundle.
Yes, thank you. Can I just have insight into the postmortem?
Maybe just get a copy because it's one or two words that I actually missed.
Yes, copies.
Kali, would you kindly make us a few copies? I said that. Number of copies? Copies. 3 sets. Thank you, Kali.
Well, copies have been made. I'm not sure if my colleague had made copies of yesterday's exhibits for the defense,
He's
for
in the
cross-examination
process.
purposes.
I asked her, he's in the process of making it.
That's copies.
So we are both ready.
I will require it for cross-examination purposes.
Absolutely.
Thank you, Your Worship.
You've got homework, Mr. Young.
I thought I was done with school. That's fine, no problem. That's me, problem.
We appreciate it.
That's the copy. So I must also make for the defense.
Prudent defense will insist.
Mr. Naidu, are you prudent?
More than
The
prudent.
assistant from the client, does she need a bathroom break? Because
May I
think
take
it's
instructions,
at
Your
least
Worship?
5 minutes.
Your Worship, my client is willing to proceed at this stage, unless Your Worship needs.
Yeah, we're just waiting, as I'm saying.
As copies.
It's at the short adjournment, 10 minutes.
As a court business? Where do you go? No, before never mind saying I want.
Honorable.
Mr. Nadi, also reading still? I'm
Yes,
also
Your Worship.
sorry. My apologies for the silence.
As copies.
Sergeant Duke, the court warns you are still under oath to speak the truth and nothing else but the truth. Do you understand?
I do, Your Worship.
So we're still at the point where we are trying to link the injuries that was seen to the actual post-mortem. So the blood in the mouth, when we look at the findings next to mouth, tongue, and the pharynx, then it says that there's no injuries or hemorrhages in the tongue. So at this point in time, we don't know what caused the blood.
No, Your Worship.
I want us to be specific here. Was it because the lip was bleeding, because it's an injury to the lip, or because there was blood inside the mouth? Or you can't say?
I can't say, Your Worship, but I can show you the pictures of
Yes.
that were taken at the mortuary.
Maybe that will explain.
May I leave to approach the witness? The orderly is not present.
Ah, no, there is.
Oh,
And
sorry.
There's
just
so many in court.
what numbers are those? Are they numbered? Are the,
Just say out the photo number.
yeah. Are
Ball number 593. Oh, reference is A15.
they? Yeah, but are they numbered? Like as in?
A25.
Yeah.
Yeah, A25. Then on A25 of 2. Oh, A25 of
How many photos are there? Let's start there.
2. Or one page, it's one-sided and the other ones are
That's
double-sided.
okay. How many documents do you have?
2,
Yeah.
4. Okay, it's 3 pages.
3 pages, ne? And then you said 2 of them. How many of them are printed on both sides?
2.
2. Okay.
Yes.
Now
This
that-
one.
Ah, don't jab. You. You. No. When you recharge English with 5 rands. No, don't rush, ne?
Alright.
Don't rush yourself. It's fine. Look, you say it's 825, ne? Okay. I mean, from my knowledge in dockets, it's fine. Does it say 825, page 1, page 2, page 3, so on, or it's just 825 and so on?
Yeah.
How is it indexed?
Just give the photos to the state so they can see.
It's at the back of A25 of 1.
I just want him to index them.
That's what I'm saying.
Yeah,
You
okay.
can take it.
Oh, thank you, Ship. You know what?
Thank you so much.
You are going to exercise if you take
Whilst
one
you-
page. Take all of them. Yeah.
Whilst we're having a look at that,
As a copy.
can I maybe just ask, where do you find the wording? And I apologize for not seeing it. The words, there was no defense injuries.
Yeah.
On the post-mortem.
Where do I find what?
Yeah, you were reading into the record that there was no visible defense
Yes.
of injuries.
Yeah.
Just tell me where on the post-mortem the wording is found, or the paragraph.
Oh, okay.
On page 4 of the postmortem, under the topic external attachments, non-present,
Number 4,
number 4.
I see it. Go to the last page, page 7. Under history obtained. The last page, page 7 of the postmortem, the history obtained.
Yes.
Do we know who gave that history to the pathologist? Who gave it?
From biology section.
Yes. Under the wording additional observation, then there is in bold history obtained.
Mm.
Who gave that history to the pathologist?
check.
I'm asking because the history given is peculiar. If we don't know, I suppose that's something that the pathologist at some stage will clarify. Can I show you where? The highlighted portion.
No, I saw it, Your Worship.
Did you see
I w-
it?
Yes, I was checking
Look at the
the.
highlighted portion on my document. And you're referencing the history given as peculiar. Do you see that part?
Yes, Your
Where does
Worship.
it come from? You don't know?
Histology report.
Yes.
The
You
one,
want to know who's the person that gave the doctor, the pathologist,
Yeah.
the history, as
No.
contained in that block.
that one that's under additional observations, Your Worship. That's the one the court is directing you to.
Bring back my document.
I
You
just,
see-
I just need to understand your question, Your
I
Worship.
want to know who gave that history to the pathologist.
And at the lab.
Someone I could tell the pathologist this. She could not have known it. You know who told her this?
Who told the doctor
Yes. This.
about the histology?
No.
Yes.
What?
It is history obtained.
Yes.
Let me read this, Your Worship. Reviewing doctor, tissue taken.
Is this something that she concluded?
The blood was taken to lab for histology to
Your
be.
Worship, may I?
Thank you.
Okay, that's fine. Mr. Tigone, calm down.
Right.
Ehle sumoya. Now, look, there's that paragraph that says specimens retained. Ne? You see on page 7 of the postmortem.
Yes, I'm there.
Okay, and then yes, it will show you. Then it will have that table, isn't it?
Yes.
Yeah, let's go past that. Then the next one is that is highlighted in gray. Then it's exhibits, ne? You see that part, ne?
Exhibits.
Yeah. There's that. Yeah, where it says exhibits. Look at me.
It's a heading.
Look at me. Yeah, this heading. Isn't that it says exhibits there? I mean exhibits here. You see?
Which means the witness should be.
All right, yes.
The
I think-
26-7.
yes, yes,
That's fine.
I see that one.
Yeah. And then below that, and then there's a table, isn't it?
Yes.
Below the table, what does it read?
Description
What does it read?
or additional observations.
That is where the court is asking you. So read that history.
I don't want to.
No, I'm just saying, not read it out loud,
Yes.
Worship. So I'm
Thank
sorry.
you.
Thank you,
Thank
Worship.
you.
Thank you. Just read it to yourself so that you just read it to yourself, ne? That entire those 1, 2, 3 sentences there, ne? You see there, ne?
Yes.
Yeah. What the court is asking you is, okay, that information that is contained there,
In that block.
yes, how would the doctor have obtained that? Who would have told her or him that information? That is what the court is asking. Do you understand the question?
Okay, there's this form called SAP 180. I need to go to it and check because that is the informant of what happened. I'm so sorry, Worship, I didn't understand the question.
That's fine. So the SAP is 180 whatever. That's
Yes,
fine.
it will tell who gave that information.
Has anything come back from the kits collected?
Mm,
There's a few kits that were collected here. Anything come back as yet? Any result?
it's only that of the pillow that I have this far.
Nothing from the kits.
No, not yet. Oh, I must tell you, Worship, who gave this
If you
information.
have the SAP S180,
Okay. I know the writing, but the person didn't write her name on top. I know who completed this, which is,
Who is it?
it's Sergeant Shabang. It's her writing that completed this 180 with that information on it.
And do you know where Sergeant Shabangu would have gotten the information from? Who would have told him or her that information?
If you don't know, you can say so.
No, I don't worship.
Say, continue.
This is just on that. Just there, page 7. See the specimens retained.
No, I've gone to SAP 180. Now I must go back this side.
It's okay.
All right.
It's 837.
Yes.
You're right, page 7. Yeah?
Yes.
All right. There, where it says specimens retained. Yeah?
Yes.
And then there's that table, isn't it?
Yes.
Tells you what was collected by the doctor.
Yes.
What the court was asking is, from these items that were collected, were the results that
Yes.
came back?
Yes.
Yes, please tell the court.
I have a histology report and toxicology report that came negative. Nothing was found of poisonous. No any, or must I read them the way they are noted here, Your Worship? Okay, this is a review of toxicology results. On 16/05/2025, I, Dr. Imefa Abrabatu, conducted a medical legal post-mortem examination on the body hearing. The death register number 593/2025. On 30 June 2025, in the course of my duties, I perused the toxicology report with forensic chemistry laboratory reference number JHB TO 934/2025. The results of the report were the following: no drug or pesticides detected in the bile, no drugs or pesticides detected in the blood, no drugs or pesticides detected in the gastric content. The content of this affidavit, to the best of my knowledge and belief, is true and correct. That was her review after receiving this.
Next one.
Histology.
You've done histology, toxicology. Do histology DNA.
Okay, this is the statement for Maliviwe Mating. On 27 May 2025, a toxicology kit sealed with T15557 and labeled Florida Case 234/5/2025 and road report DR number 593/2025 was received from the Road Report Forensic Pathology Services. The toxicology kit was kept in the access control area until analysis on 20 June 2025.
We don't want that. We don't want that. Go to histology DNA.
Let me check it.
Remember, these kits was obtained because there was something wrong with the pathologist in the history given.
Histology report, toxicology report. No, those are the documents I have, Your Worship,
So there's no result of DNA.
for DNA.
Yes. Under type of specimen, there's other specimens collected, apart from the toxicologist.
Your Worship, I guess this is the court. Sure. Sorry for intruding. Your Worship, it says the exhibits were handed to SFO ME, Sage. Hopefully, the witness has a statement from that person or that laboratory. It will assist with the court's questioning. If it was returned from that particular person or laboratory.
But I just know there's the outcome.
Just to
Yes, I hear what
fast
you're
track the
saying.
process, Your Worship.
Yes, but I, what was that you do?
What the court is asking. All right. You see why, isn't that you are saying the history obtained was from the SAP 180, SAPS 180, and someone said something, isn't it? They related that information that was now subsequently given to the pathologist, and hence it was entered here, isn't it? Ne?
Yes.
Right. Now, in the process of conduct, let's, so that I get the gender correctly, is the pathologist a male or a female person?
Female.
Thank you. Now, in her performing her work, the pathologist then collected the samples that are now tabled under that heading, specimens retained. Yeah? So now we have read out to the court the histology. Isn't that there's a type of specimen that was collected, and examination is histology, isn't it? There on the table. Yeah? One. Number two, then there's a on the second row of that of the table in column 1. There's a type of specimen collected. Then there's toxicology. Ne? You then explained that, isn't it? Now then, row number 3 of column 1. Then there's the type of examination there, DNA. Do you have results for that?
Not yet.
All right. Do you want to go? You said there's a DNA report, is it not so?
Yes.
Do you want to check it first before I move from that? You have it, yeah? All right. You remember you told the court that the pillow was collected, isn't it? And then taken for analysis. And the material now collected from the pillow was compared to a control sample that was taken from the child, isn't it?
Yes.
What is the number there of the control sample that was taken from the child?
DNA, okay.
Mm.
It's 19, oh, 19D 2A
Mm-hmm.
D1119.
Mm-hmm. Mm. Now let's go back then to our postmortem. Yeah. Oh, page 7. Yeah.
Right.
Are you on page 7 of the postmortem?
No, I was just thinking.
No, share your thoughts. Share your thoughts.
Oh, the ones labeled on the postmortem are done by the mortuary. The ones that we looked at now, it's when LCRC goes to the scene, they are collected, so it's two different things. Therefore, those that are reflecting on the postmortem were collected from the mortuary.
Yeah.
The
These
question still remains,
Yeah.
do we have analysis? Do we
Go.
have
results, not yet, Your Worship.
Go to the
Postmortem.
postmortem page.
But
I was
I'm
trying to direct to the.
It's something.
Yeah, on page 7. Yeah?
Yes.
Now, under column 2 of row number 3, that remember it says DNA, ne?
Yes,
Then the next column is seal number, ne?
yes.
And then that very row number 3. Just read that 19. I like to laugh.
All right.
So, do you still retain that we haven't gotten results for that?
Oh, no, we do.
Yeah,
No, we do.
that's fine. Okay, so are we then to conclude? Okay, so that is the DNA result.
Yes,
for
when
that.
I'm looking at that seal number,
Yes,
it's the
sir.
same seal number as this one
Okay,
of
so
A35.
okay, no, that's fine. We are only human after all. Yes, sir. Thank you. Now, so one is to conclude that the sample that has not returned for analysis is that one on row number 4.
Yeah, D7.
Yeah, thank you.
Which is PW.
As a copy, please, yes.
That's copies.
So again, what is the results for that? For that DNA, what was the result
They were positive, Your Worship.
for the deceased?
Yes, Your Worship. The control sample and the DNA on the pillow.
I want to play devil's advocate. If the results for PW 30012022286 comes out positive, are you following what I'm saying?
Yes, I'm listening, Your Worship.
If the results comes out positive, does it steer this investigation into a different direction?
Different direction. Yes, it takes us to a direction that makes us to be here, Your Worship.
State, are you following my...
Absolutely, Your Worship.
I want to link that to the last sentence in the history of things. Because if that comes out positive, do you understand what I'm getting at? Mr. Naidu's mind.
No, I do, Your Worship. Perhaps the challenge is that we are not being direct in the wording, Your Worship, and I accept
Why we're not being
why we are not
Yes.
being direct. Yes, but okay. I'm not. Okay. if I may ask, I'm not sure if I may ask, okay. Just for the moment, let's go back to that part where it says specimens retained. That paragraph, right? I mean that part. Line number 4, line number 4, and column number 1, You see that sentence that ends with D7. You see that?
Yes.
Yeah. See the words that I used there, the first 2 words that I used there. You see them, Yeah. We are not referring to them deliberately. That's fine. But I just want to ask you, is there any indication of that in the postmortem?
Let me go through the postmortem.
You don't have to say the words, but you know what we are implying.
Yes.
You have checked, it's not there. You won't check.
I can confirm that, Your Worship. I've also
Fine.
checked.
That is as far I was confirming. Thank you. No, that's fine.
So for the record, the result is still outstanding.
Yes.
As a copy.
Even though that result could have a grave impact.
I agree with Your Worship. At this stage, we...
When are you expecting your results? For the record.
I'll check with them, Your Worship.
Question mark. Let's proceed.
Tell the court, please.
Your Worship, I just may take us to the proceedings. The photographs were handed to my colleague for it to be indexed.
Thank you. Hey, I'm lost, to be honest. Thank you very much. No, thank
I
you.
also want to share the
Thank you.
I have not perused as yet, Your Worship.
Show that it's in.
Oh, yes. He hadn't, Your Worship, because I was trying to check the number.
Just turn the focus around.
Yeah.
It doesn't show the front.
Oh, yeah.
The background.
Oh, yeah. Just hold on a minute. They are marked, Your Worship, as 821, 825-1, 825-2, and 825-3. Yes. And then
Thank you, Your Worship.
And then, Your Worship, just for the record, 825, Mr. Knight, you've jumbled them. It's fine.
Good.
It's fine. 825-1 is the page is printed on both sides.
Understand.
Yes, Your Worship, and then 825-3, the same, Your Worship.
Have you retained your writing side?
Yes, Your Worship.
Thank you.
Let's copy it. I'm instructing if I may ask for your services. Can you handle it? Oh, yeah, yeah. Thanks.
For half an hour lunch adjournment now, or is there has to be on the wrap up first?
Those are the photographs about
Yeah,
blood in the
the,
mouth.
the,
Yes.
the court observed
As
the,
copies.
the, what is proposed to be
You should be
the
injury to the
injury
lip.
to the lip.
Mm.
Yeah. It's proceed.
Oh, there's copies. Yeah, I know.
We will adjourn at 1:30 for a half an hour lunch adjournment.
As copies.
As you go, pieces.
Which paragraph was it on?
Paragraph. N.
P. I finished P. Yeah, I finished P. Q. Yes. Now it reads, I was even informed that Jayden's blood-soaked underwear was found in the bathtub on the... Huh? Right, yeah. That, let me repeat it. I was even informed that Jayden's blood-soaked underwear was found in the bathtub on the 16th of May, 2025. This is impossible, as we had so many people use the bathroom on 14th and 15th May 2025. Someone would have most definitely saw the underwear in the tub and alerted the police. What is your comment with regards to that?
The impossibility part going down, I cannot say anything about that. What I can say is that it was indeed found in the bathtub.
What does
Not
that mean?
blood
Sorry,
stain.
Yoshif.
Not blood soap.
No, with no blood, Your Worship. No blood.
Is that all?
It's
But
only,
look at-
it's only the towel that has traces of blood, not the underwear.
Okay.
And the towel is not mentioned there.
I just want to clarify this part. Would you have a remark with regards to where the applicant is saying, we had so many people use the bathroom on the 14th and 15th of May.
No, I cannot say anything to that because I don't know what was happening there.
Oh,
I have never been to the room on the 14th and 15th, so I don't know what was happening.
but on the 14th, you earlier indicated that Captain Hoffman had control of the scene.
Yes.
Okay. Okay, let's get into that subject, rather the heading that's written personal circumstances, which is marked as paragraph 18. I am 31 years of age. Not me, that is what the applicant is saying. I am 31 years of age and I am married. Once again, that's not me. Yet separated from my husband since 2022. I was the mother of 2 children, both of whom have passed away. I was 18 years old when my first child was born and passed away 2 days after birth. Do you want to say anything about that?
No.
Thank you.
No.
I was the sole breadwinner for my son Jayden-Lee and I. Let me read it properly. I was the sole breadwinner for my son Jayden-Lee and I. Since his death, I have been living with my mother and brother, and I provide financially for my family. Do you have a remark about that? Paragraph 19.
Providing them, I don't know about that.
No, right, fine. I support my mother and brother. My net monthly income is an amount of 17,500. This money is utilized to support the family financially and to meet all our expenses, inter alia, expenses of the household, food, clothing, transportation costs, and other personal expenses. Kindly find enclosed my confirmation of employment letter marked Annexure A, my character reference letter marked Annexure B, and my pay slip marked Annexure C. Do you have any comment with regards to that?
No.
Thank you. Paragraph 21. In any event, you did confirm that she's employed, isn't it?
Yes, I did.
I have an alternative address being 62 Havenwood Road, Tenants Park, Verulam, Durban. This belongs to my father. I have been informed that the investigating officer has already confirmed this address. Earlier in your testimony yesterday, you did indicate that you confirmed it through your colleague.
That's true.
All right. Anything that you want to add, perhaps, or say, with regards to that?
With the uncertainties I have in getting more information, I couldn't reach out to the biological father to explain more things that I needed to know.
Such as?
How long he has been staying there, whether he has a lease agreement to be staying there if he's renting, where has he been staying before then, for how long, because I was trying to check whether is he someone moving from one place to the other. So I couldn't, because my colleague only said I verified, he gave that statement, and the father only said he's staying there, he can accommodate the applicant. But I couldn't, the person is not answering his phones when I wanted clarity on those.
But how did you reach out?
I was calling with the provided phone.
You stripped me off a punchline, it's fine. You called via phone. Yeah, no, that's fine. I don't know. Okay, paragraph 21. I submit, that is the applicant, I submit that if I'm not released on bail and allowed to resume my employment, my family and I would suffer financially. We are an extremely close-knit family and are not well to do. My salary contributes to part of my mother's monthly expenses, our food, transportation costs, and my personal expenses. My family and I would suffer emotionally, financially, and mentally if I am not released. What is your comment with regards to that? Paragraph 22.
I mean, when she says to resume her duties, from the information gathered at her workplace was that she has been placed on leave since the day her child passing. So as she's before this court, her workplace is still regarding her as employee until end of September. So it's not like tomorrow is gonna be going to work or next week. That is the information I received from her employer.
It says she's on leave until September.
Yes.
But then is she receiving her salary? You know, it sounds like a stupid question, but let me ask it nonetheless. I'll take the risk. So she's still earning a
No,
salary?
I never asked.
No. 23. I have lived in the Gauteng area in excess of 17 years, and I am well known by the community at large within the area in which I work and reside. Do you have any comment to the
When she said she's well known, what I know is that she may be well known through this case. I know with this case, she may be famous with how things unfolded. I'm not sure which one is he referring to when she says she's well known.
But in fairness, we can't dispute that she's been here for 17 years.
I cannot say anything about
Okay.
that.
No, it's fine. Perhaps she's a people person. Maybe in fairness, she is known by the community. Anyway.
Why can't you dispute? Next one.
I will be, paragraph 24, I will be able to raise some money with the assistance of my family for the purpose of paying bail. I am able to afford an amount of 5,000 rands for bail. However, I will leave the amount of bail to be decided by this honorable court. Suppose you don't have a comment.
No, I don't.
That. No, thank you. Paragraph 25. I, however, respectfully submit that my personal circumstances and factors mentioned herein above illustrate that there is no likelihood that if I was released on bail, I would attempt to evade my trial. I do not have the mean, I'm reading it verbatim, I do not have the mean nor the support to flee from this country. Hence, I am not a flight risk. Yes, what is, you have a comment with regards to that? This is paragraph 25.
I cannot really say that she cannot evade trial if released. I cannot really say she would not.
Yes.
As I mentioned earlier, that the address that she has given, the things that I needed to know, I was unable to. So those are the things that would maybe assisted me in saying something if it's not a flight risk. Like I said, I don't know how long this person where has been staying before this address, and whether is he a person that moves from one address to the other. Because if such, like maybe from the previous address he stayed 6 months, if a person is released, possibilities that the person can move to the other unknown address, that person can then be difficult to trace if he doesn't attend the court.
That's okay. You know, let's perhaps just to be fair as well. Let's the father did make an affidavit, is it not so?
Yes.
Yes. You don't need to read out his details, but just for record and to be fair, just read the contents of his affidavit.
Statement of the affidavit of the father reads as name and surname Michael Linton Lucas. ID number.
You don't have to read those.
All right.
Just go.
I am an adult male residing at number 62 Havenwood Road, Terrace Park, Verulam, KwaZulu-Natal. I have been residing at the address for 1 year and 2 months. I am Tiffany's biological father who is willing to keep Tiffany Nicole Meek under my wing at my residence under full care and supervision for the duration of her court case. I will ensure that she does not enter the roadblock area except for her court appearances. My residence is a suitable and stable environment for Tiffany to be safe and out of public scrutiny.
So according to you, that is not sufficient. You wanted to ask him more about other things. No. If given the opportunity, would you perhaps, I'm not sure if my colleague would be able to assist or willing to assist, but would you try again perhaps if
Yes.
Okay, that is fine.
Just for the record, Your Worship, the defense was not approached by the investigating officer for any help whatsoever, even though the alternate address and contact details were supplied on the accused's first appearance to the investigating officer. It's not as though the defense is not cooperating with him, Your
So
Worship.
noted.
As the court pleases.
Okay. Perhaps we'll come back to it later. No? Paragraph 26. I would like to record, I would like to record at this early stage that if the state persists with the charges against me, I wish to stand my trial, and that I want to explain insofar as I can, and will also lead evidence, if necessary, that I am not guilty of any offense. Suppose you want to have a comment with regards to that.
Yeah.
Thank you. 27. I am still in shock and are coming to terms with allegations and charges, as I have been the person asking for proper investigations into the death of my child, and I verily believe that the police have failed in its duties to properly investigate this matter. My family and I will now have to attempt to engage the services of a private investigation company, as we have no faith in the investigation team from Florida SAPS. Do you have a remark or comment with regards to that?
All I can say is that Florida SAPS team is trying its best to do justice for the late child. That's all I can say to that.
All right. Then paragraph 28. I will now, on the advice of my legal representatives, deal with what I am no, that's something, yeah. Okay, yeah. You know, before I make a fool of myself, let me read it. We can deal with that after lunch. Yes. May I stop here, Your Worship? Thank you.
Thank you. The court will be reconvened at 2 o'clock sharp. Time is going out. All rise, okay? Thank you.
Oh. Ah. Okay. Just so at least so that we are clear, and perhaps you also have an idea of the direction perhaps your evidence should take, if I may put it that way, not what you should say, but at least in your explanations, the line of thinking I'm asking you to at least consider. The factors, the information that we will deal with relates to the part of the Criminal Procedure Act, number 51 of 1977, those paragraphs, section 60, subsection 4, paragraphs A to E, relating to whether a person, an accused person, or is likely to evade trial, whether their release on bail would, affect the administration of justice and so on, whether there would be, public outcry and so on, whether a person is a threat to safety of witnesses and so on and so forth. Ne? Do you understand? Yes. So now, when we deal with these aspects that the applicant has already referred to in her affidavit, for expediency, I'm just asking you to, if you have any comment thereof, am I saying it right? If you have a comment in relation thereto, perhaps let's deal also in your responses, perhaps let's deal with, when you deal with that aspect, also deal with your sort of attitude, if I may put it that way, or your opinion, or the direction of thought that you are requesting the court to go insofar as considering that. What I mean, for example, is that when we deal with this aspect, let's say, about whether the applicant might evade trial and so on, you will answer, if you have an answer in relation to what she says in her affidavit, and then you will also add whether, insofar as that is concerned, what is your opinion and the direction of thought that you wish the court to adopt. Do you understand?
Thank you. In coming to the aid of the state, let's just use the affidavit as was deposed to. Let's just deal with the actual headings. So that is A. You can read A and see what is the attitude. You can just read B, see what is the attitude. Read C, only the top headings.
Not the contents?
No.
Oh, I see.
Unless there's something specific in the content.
That is what I'm trying to go through, Your Worship.
Yeah.
What I was saying is, because I don't want, I'm trying to avoid us repeating.
Exactly.
We find that maybe the answer is already in the content of in the affidavit.
Yes, because we accept that the investigating officer has familiarized himself with the content of these paragraphs. So what I'm saying, let's just deal with the headings, and if there's specifically something he wants to raise pertaining to the headings, then he can do that.
We accept the court's direction, Your Worship, in that regard. So let's go then to page 9, paragraph 28. It starts off by saying, I will now, on advice of my legal representatives, deal with what I am informed are the various factors that go to a proper assessment of the application there herein, which illustrate that there are exceptional circumstances present which would, in the interest of justice, permit my release. The first is factors illustrating that if I am released on bail, I would not endanger the safety of the public as envisaged in section 60, subsection 4, paragraph A, read with section 60, subsection 5. Did you read that paragraph, the contents therein? What the applicant says in relation to
the one
on page 9.
Old.
On page 9, paragraph 29.
Must I read it?
No. The court is saying you have read that. So what is your what are you saying about that information?
Okay, that is what is my position with regards to what I would say the court should take into consideration is that if the applicant is released, I don't know whether is that the direction the court wants me to.
The question you must answer is whether she would endanger the safety of the public, as envisaged by section 60, bracket 4A, just that one. We'll go through all the headings.
Whether the applicant would endanger the safety of the public.
Yes, she would, given the outcry of the public outside, she would.
Not the reaction of the public towards her release. Ne? But what the question is whether she, if now,
endanger the public.
Absolutely.
Yes, I can say she would, in case she is confronted. In defending herself, she may.
Okay, fair enough. If she's not confronted?
No, I don't think that can happen.
But you are saying in this case there's a greater likelihood of her being confronted.
Yes. No, I was answering the one
No,
of.
I hear what you are saying,
Alright.
but we are dealing with likelihood. So we need to link the facts or the assertion that you are saying to a concrete fact. Proceed. Page over. The next heading.
Let's go to page number 10, paragraph, whether there is a likelihood that, she's saying that, that whether there is a likelihood that I would attempt to evade my trial as envisaged by section 60, subsection 4, paragraph B, and read with section 60, subsection 6 of the Act. Well, and then she lists the factors therein then, in paragraph 30.
Okay.
Yes, sir.
Given the sentence that may she face in case she's found guilty, I see a likelihood of her evading trial if she's released. That is my point with regards to that sentence or to that paragraph.
Is that all?
Yes, that is all.
Okay. But before I move on that aspect, I just want to ask you, perhaps it's an opportune time to ask you this. You were raising concerns about her father's address, and certain other information that you wanted. Were you able to get that information up to now?
Yes, I was able.
Yeah, what information did you get?
I have spoken to the father.
Mm-hmm.
He told me that he's leasing and he doesn't have a written lease agreement. He has a verbal agreement with...
Just a moment, please don't rush. He's spoken to the father. He said he has a lease agreement.
A verbal lease agreement with
Verbal.
his landlord.
Period.
Yes.
1 year, 2 months.
If I may, Worship.
Yes.
Thank you for the court's question. If I may, now, is that how long he's been staying there, or is that the
remainder?
Yes.
No.
How long is the lease for?
Is that how long he has been staying there for, but he doesn't have a time frame that he's gonna be or staying there. He's staying on. He said he doesn't have a period as to how long is he gonna be staying there, but he's still gonna be at that address.
Okay. Remember, you also said you wanted to ask things like where has he been before and things like that. I think.
Yes, he said he was staying in Wentworth or in a flat for a period of 5 years. and the owner of the flat came back. That is the reason why he had to go look for other place, which is the current address. So I was happy with what he gave me.
But the gist of that is that the father doesn't have a permanent address. Are we to understand that even at the previous address he was renting, so to speak?
Yes.
Okay.
Before we move on to the next heading, I see from paragraph F that applicant submits that she has a defense to the allegations, it being one of alibi. At this juncture, has anyone come forth to make a statement in that regard?
I don't understand your question, Your Worship.
State assist.
Okay, that's fine. Isn't that the accused is claiming she says she has an alibi, ne? You know, in paragraph F on
Yes,
page
go to
11.
paragraph.
Yes, page 11. That's what the court is highlighting to you. Now, you know, has anyone come to make a statement to affirm that alibi?
The alibi from the accused.
Yeah, even though we don't know what it is, but I'm just saying to say, Tiffany, I'm here to support Tiffany, and this is what would have been her position on the day.
No, I don't have such information.
May I proceed then?
Okay.
Let's go, please. Let's go to page 12. Now the applicant is also saying whether or not, that is the next heading, whether or not there is a likelihood that if I was to be released on bail, I will attempt to influence or intimidate witnesses, etc. Pardon me. As envisaged by section 60, subsection 4, paragraph C, read with section 60, subsection 7 of Act 51 of 1977.
With this one, given the fact that there is still outstanding investigation to be completed, I would say she would, if she's released, there is a likelihood that she may destroy or conceal the outstanding investigation.
Which else?
I still need to obtain statements from people close to her. To people that are close to her, I may have difficulties in doing so if she successfully influenced them not to.
Just off the cuff. Does the security have not necessarily OB entries, but do they have access control for that specific day, which was the 13th?
Access control, no.
Meaning visitors who visited the applicant on that day. Is there any reference or confirmation of that anywhere?
Nothing, Your Worship.
So for all intents and purposes at this stage, we safely accept that it was only the applicant who was home at that particular time, on the 14th and the 13th.
Yeah, that's correct, Your Worship, until the child returned.
As court please. that all with regards to whether the applicant would attempt to influence or intimidate witnesses?
Yes.
It's now very well said. Let's then go to page 13, paragraph. Yeah. The next paragraph is 32. It says, she says, whether there is a likelihood that I, if I was released, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, etc., as envisaged by section 60, subsection 4, paragraph D, read with section 60, subsection 8 of Act 51 of 1977. What is your comment with regards to that?
There is a likelihood that the safety of the accused might be jeopardized by, say for instance, she's released, if I may give an example, and something happens to her, given the outcry from the community. If she is no more before this court to give whatever that she give in her defense, because something happened to her, the public may not have trust to the justice system, or to the if the justice system functions well. As I said earlier, that the public is not happy about what happened. So if she's released, then something happens to her that will make her not to come before this court. We will not have answers as to what happened. Therefore, I think it will jeopardize the functioning of the justice. There is a likelihood that it will jeopardize the functioning of the justice.
Okay. Then the next one is whether there are exceptional circumstances causing a likelihood that my release will disturb the public order or undermine the public peace, security, etc., as envisaged in section 60, subsection 4, paragraph E, read with section 60, subsection 8, capital letter A of Act 51 of 1977. Yes, what is your comments with regards to that? Do you have any?
I would say there is a likelihood that it would undermine the public peace, because people are feeling not safe given the circumstances of the case that made us to be here today. So if the public sees her outside, I believe that can disturb the public. And we see communities taking law into their own hands because they feel like we are failing as the state or as justice to keep people where they supposed to be if they committed certain crimes. Therefore, I'm saying it would disturb. There is a likelihood that it would disturb the peace of public.
Yes. Anything further? Is that all? Okay, no, it's fine.
Just for the record, this is based on what factually played out. It's what you have observed.
Yes, Your Worship.
And that means there's been protest action.
Yes, Your Worship.
Yes, explain to the court.
Twice, I just cannot recall the dates. A group or community group from Fleurhof, they took a petition to Florida SAPS whereby...
Are you in possession of that petition?
I don't have it with me now
Can
here.
we get access to that petition?
I can look for it, Your Worship.
Because that speaks to what you are saying. It speaks to the assertions that's been made. Do you understand?
Yes, Your Worship.
Yes. So a group with petition saying
A big group of community that went to Florida SAPS twice. At some other day, the first day they tendered their petition at Florida SAPS, whereby they demanded that the responsible person for the death of Jayden-Lee Meek should be brought to books, and they needed agent investigation into the matter because they were not happy with what has happened. And it was accepted by the management of Florida SAPS, and they promised that SAPS will do its best to bring the perpetrator to books. So I believe they have learned now. Okay, the second time again, they camped outside the police station, whereby they were also demanding. On the second time, I'm not sure whether there was a petition.
when
But
can you have petition available? I'm
The
sure
first-
the defense will want to have a look at it as well.
the first one again,
When can we have it available?
I believe tomorrow.
Tomorrow.
Yes, Your Worship. So, with that, Your Worship, when I say likelihood, I mean that knowing how is the community reacting to situations like this. So the peace of the community, surely it would be disturbed if the perpetrator or the applicant is released.
Thank you. We therefore wait those documents. Yes, proceed.
Let's go, please. Okay, I'll just run through. I'm not going to read out the paragraph, but I'm just going to run through some paragraphs with you because the heading under which the following information is contained has many things. It's not the same as before. So, for example, we are now on page 14, where it says other factors as envisaged by section 60, subsection 9. It says, I respectfully submit that the Honorable Court ought to decide in weighing up the interests of justice against the right to be released. That is my right to personal freedom and the prejudice that I'm likely to suffer by taking into account the following factors as envisaged by the Act, namely, A, if I'm not released, I would probably remain in custody for a very long time. No. If I'm not released, I would probably remain in custody for a very long period prior to the matter going to trial. I have been informed and verily believe that the court rolls in the regional court and high court are booked long in advance. I'm informed by the legal representatives that it is likely that the matter may be transferred to the high court. However, in my favor, it ought then to be taken into account that it is of utmost importance to be able to prepare in the matter. If I'm kept in custody, I would have insurmountable difficulties to prepare for trial. Do you have any comment with regards to that?
No, I don't.
Thank you. I submit that it is also extremely difficult for me to prepare for my trial whilst being incarcerated, in that there are limited times in which to consult with my legal representatives, which have to be arranged in advance with the prison authorities. There are no recording devices and other time-saving devices allowed at these consults, and the number of my legal representatives capable of consulting with me are limited. Do you have any knowledge of that? Do you have a comment with regards to that?
No.
Okay.
How does consultation work?
I was about
For
to
my
ask,
edification.
yes, is it?
How does it work? how does consultation at the prison work?
I believe
If the
with,
assertion is that they can't prepare for defense, how does it work?
I'm not sure. Yoshi.
Okay.
I'm not sure, Yoshi.
But
Proceed.
thank you, Yoshi. But you do accept that there are, unfortunately though, plenty of accused in custody whose matters have proceeded and their representatives have taken instruction.
At prison.
Thank you, Yoshi.
What I know is that lawyers do go to prison to see as to with the procedures of how do they see their clients. But what I know is that they do go see their clients.
So it is possible to consult at prison.
Yes, but
Thank
as
you.
to how, I cannot tell.
It's okay. Should I be further incarcerated? The financial prejudice that my family and I would suffer is huge. I also stand the risk of losing my job and will be unable to afford proper legal representation. I suppose you don't have anything to say about that, no?
Yes.
Okay, it's fine. Yeah, let's go to page 16. Yeah, I just want to ask you, just this now, it's an opportune time to ask you. Now, in paragraph 38, the applicant says, if released on bail, I undertake to deposit with the clerk of this court the sum of money determined by the court, it's fine. B, to comply with whatever conditions this honorable court deemed necessary to be imposed upon me when released on bail. Let me ask you, hypothetically, if I may, I'm not sure if it's fair to put it that way, but let's say the applicant is indeed released. Let's say the court finds factors indeed that the applicant should be released on, and then she is then ordered to indeed stay in Verulam and is and then let's say, for example, conditions like report to the police station, maybe because she's so far, for example, maybe 3 times a week and so on and so forth. Now, what would you be in a position to monitor that?
I am unable to monitor that as it is the jurisdiction of Roodepoort Court. When she is in KZN, I will be now giving police officers of KZN the job of Gauteng Police, the work to monitor, of which I don't think they can do the job of Gauteng, whereas they have job or work of their own. I haven't had such experience, but I don't think people would monitor things that the way I would monitor them when the person is here in Gauteng. However, then it's an unfortunate situation that she needs to be out of the area, but to monitor that work, it will be difficult for me. It's impossible.
Okay. Paragraph D, if released on bail, I undertake to stand my trial and to attend punctually to any and all trial dates until finalization. She did not say until further. Says to stand my trial and to attend punctually to any and all trial dates until finalization of the trial. I want us to explore that quickly. All right. Look, the applicant herself asserts that if she's released on, if she's now detained in custody, she might suffer prejudice because the roles in the regional courts and high courts far. So I don't want to misquote her. Let me go back quickly.
Bottom page 14.
Oh,
top
thank
page
you very
15.
much. Thank you, Your Worship. Yeah. Say, if I'm not released, I'll probably remain in custody for a very long period prior to the matter going to trial. If I have been informed and verily believe that the court roles in the regional court and high courts are booked long in advance, I'm informed that, yeah, just one dead. And now, you know, we book matters at times for consecutive days. So sometimes it's called a rolling roll, so to speak. Ne? And in the High Court, where the matter is likely to go, it is booked now for 2 weeks. Ne? In Gauteng local division. And the applicant is staying in KZN. Ne? And the reason, isn't that, okay, it's safer for her in KZN, is that the reason? No, but whatever, I don't want to speculate. But what I'm saying is, insofar as her own safety, from what you said, insofar as her own safety is concerned, I can understand one day. Now, if she has to come to this court, I mean, into Gauteng and attend court daily, who would be able to ensure her safety?
With that one, I cannot put my head on the block to say I can safeguard her from her place, whether from Durban to Roodepoort or from whichever court. Her safety, as I said, it will be compromised if she's outside. I believe where she is, she's safe. There are so many dangers outside. As I said, I cannot say I can guard her from point A to point B. No.
I think the problem the state is alluding to is a practical one. What the state is saying in the High Court, we've got a rolling roll, continuous rolls, meaning the matter is set down for 3 weeks to run continuously. So if that is the case and the matter is set down in that fashion, it will mean that the applicant has to be here one day after the next. It means practically she's not going to travel to Durban every day and go back and come back to court, which practically therefore implies she will have to be in the province. It's a practical problem the state is highlighting.
No, I understand that, Josh. I understand that, Your Worship, and I believe with that having brought in here, it's clear that the place that will make her to attend in such situations is when she is in custody. It's easy for us to transport people day to day. Anytime a person is needed in court, if she is in our prisons here in Gauteng, whether it's needed in the afternoon or in the morning, we make sure that suspects are taken where they're supposed to be. In a case whereby then she has to travel from KZN to Johannesburg every day, I believe that is impossible, not unless she's here, of which when she's here then it's a risky situation for herself because the community may endanger.
What it then causes is the consequential problem of not being able to comply with bail conditions. Do you understand? If the conditions is to report 3 times a week in case of thing, then there will then inadvertently be that breach. So what the state is just highlighting is practical problems for the record. I apologize, proceed.
Let's go, please. Just give me an opportunity to. I think Sergeant Diko, do you I don't know who said I'm the sergeant that was testifying, but you are Sergeant Diko. Is it not so? Yes. Anyway, but what I wanted to ask you, or what I want to ask is, do you have anything further, sir, to add that you would like the court to consider in its decision whether to grant the applicant bail or not?
Yes, I do. The community at times, it loses hope to the justice. I need, I would request that the court consider the fact that the community, not only Flair of community, the community of South Africa at large, it's so concerned about what happened to the child that makes us to be sitting here. And if the suspect of the applicant is released, the community, I'm not talking about community of Leo. She may be in Durban, she may find people waiting for her. The way I see how people are acting. So if the court decides in whether granting or not, I humble request that the court consider the fact that the community of South Africa may make us not to be trusted as people that are having a proper way of doing things. I do not have much, but I need the communication, the community of South Africa to be considered in making decision. As I said, that there is that crowd of that day in Florida I saw. And I know these people are not only from Flair, people are from Eastern Cape, but now people are here in Gauteng to work. A person happens to meet Tiffany or the applicant in Durban or wherever. Anything bad is possible to her. Not just that community is concerned about the child, but people may harm her.
Just out of interest, okay, you are continuously highlighting, possible harm to the person of the applicant and so on. But why would that be? Why would the community want to harm her in particular?
The community is angry that how when this thing, when it started unfolding, the applicant was the one directing them to a certain direction. And when now the investigation turned into where we are, the community felt like she misled them. And with that anger on top of the anger of the killed child, it's just something that may be out of hand if community happens to see her where she can find herself in, outside the court or outside the precinct of the state.
Okay. Is that awesome?
Yes.
That is very well. And the rest, I just want to place it on record. Your Worship, the rest of the information contained in the applicant's affidavit, I have not taken the investigating officer through because those are assertions, she's making assertions of conversations between herself and General Kekana and other people that the investigating officer. Absolutely. And people that don't concern the investigating officer, I therefore do not see it expedient or it should not take a case anyway, Your Worship, to just make reference to take him through that. And having said that, Your Worship, I have no further questions.
What is left hanging at this juncture is the court asked for the petition. Let's just get that evidence.
Yes.
So we want that document.
Yes. Petition.
What else?
The photos and video.
The possible still photos
Yes.
and the video.
And the
recording.
video ship, yes.
Mr. Naidu, assist me.
The copies of the exhibits to be supplied.
State, please compile your exhibit album.
Thank you, ship will do so.
Your Worship, also the reference was made to the OB entries, the occurrence book at Swazi Place.
Which
What date do you want? 13, 14?
Both days, Your Worship.
OB entries,
those
13 and 14.
oh, sorry, Your Worship. I think those form part of the bundle that the court requested. I think is what the court is asking is the information that the investigating officer was going to get.
Yes.
Yes, Your Worship.
We are trying to address housekeeping issues.
Yes.
Otherwise, things just hang in the air.
No, I accept, Your Worship. I'm just saying. Oh, that's fine.
Is there anything else?
I'm just trying to.
Your Worship.
Let me just see.
The SCP-13, Your Worship, the court did reference of that one.
That's going to be in the exhibit bundle that the state is going to provide us
As appropriate.
tomorrow.
I'm still talking to the ancestors there.
So on.
They should.
There was something pertaining to the
Your Worship, also the court requested
the school.
the
Yeah.
report of the book.
That is it.
uh,
We wanted a copy of the
book.
school book
The
that was
book.
inside
It
the
was
school
sealed in
bag,
exhibit bag.
Yeah.
and the school book reflected the day's work.
Correct.
That's one page.
Yes, that's correct.
Your Worship, also in respect of the progress of the DNA report.
Most important. May I warn the state in that regard, I am absolutely going to invoke section 60 subsection 3 for that report. I'm going to invoke it. So get your house in order. Anything else, please?
Not make up to my name.
Are we all on the same page? Are we all on the same page? You're still thinking?
The ancestors have not answered. Yes, Worship, we are on the same page.
So, we are going to adjourn the proceedings today. We're going to start tomorrow with your cross-examination. Tomorrow, I want that petition.
Oh, yes. And the,
I want still photos and video. I want the state to have compiled 2 exhibit albums for myself and the state of the photos we have at Site 2 of, as well as any other evidential material that we were looking at.
the OPs and so on.
We want the OV entries 13, 14. We want that page of the schoolwork.
Sorry, perhaps
Yeah.
if I then have the court's copy of the postmortem, I will then put it in the bundle. Or the court attached.
You can have my copy as
Yes,
well.
Worship, I'll just attach
This
it
will
to
be
the
part of the exhibit bundle.
That's correct. Thank you. That's cool.
Mr. Knight, is there anything else? Please confer with your client.
Your Worship, just to expedite the matter as well.
Yes.
I believe that the accused's phone was seized by the police and it is in the custody of the investigating officer. Your Worship, if also that could be made available, Your Worship, for the purpose of cross-examination, there's just one reference that needs to be made or highlighted to the investigating officer.
Then maybe you should have that discussion off record with the investigating officer as to what exactly. We don't want to deal with this matter as if it's the trial.
I
Because
understand.
now it becomes protracted. Do you
That's
understand?
I understand, but it's come to that as
That's
it
what I'm
is.
saying. You know what you want. Please address it specifically with the investigating officer.
I will, Your Worship, and I think
Absolutely.
I'll have to wait for cross-examination first, then
Not a
address that.
problem. Anything
As the
else?
copies.
Anything else?
None by the state, Worship, none from us.
Mr. Knight, confer with your client.
Yeah, I believe.
May I push the pen?
Thank you. What you can arrange is, we will take the court now, maybe to court 8:45, without postponement, and then in the morning I will swim dates for the town that is on the court now for the day. So we can set the postponement somehow. Does that make sense to you?
Yes, Your Worship.
Anything else before the court adjourns the matter until tomorrow?
Nothing from the state.
Nothing from the defense, Your Worship.
The time is 5 to 3. Please use this time optimally to get the information the court has requested. Ms. Meek, you're in custody until tomorrow. The matter is now adjourned. You can stand down. Thank you for your time.
All right, spoken.
Who's the man to us?